a request has been made for a bit of case law. So I'm going to start off with one of the first cases that I ever was involved with when I dipped my toe into litigation as a liquidator. And this was a case of Green versus BDO Stoy Hayward LLP. And this was a case brought under Section 236 of the Insolvency Act 1986. And this is the liquidator's investigative powers enforcement application, where a liquidator can make an application to the court for an order that an individual, a company or a body can be compelled to produce information to assist the liquidator. Remember, the liquidator enters office as a stranger to the affairs of a company. And as a result of that, liquidator has to reconstitute knowledge of the company. The liquidator's not there. The directors were there. Okay? And in the case of cases where there's been fraud or where there has been director misconduct, the liquidator has to try and assemble information to reconstitute that knowledge, because the directors have the knowledge, the liquidator may not. And in this particular case, which was a reported case of Green versus BDO Stoy Hayward LLP, this was a compulsory liquidation under a court order. And I, in my capacity as liquidator of a company called XL Communications PLC, I think it was called, issued an application under Section 236 of the Insolvency Act 1986 to look for the auditors, which in this particular case was BDO Stoy Hayward LLP, to produce various pieces of information on the company's finances and company records, etc., that we anticipated would be in the hands of the auditors. Now, what happened was this case was first initially heard in Kingston upon Thames County Court, and this was defended. And it only goes to show that there's a risk with any piece of litigation, including applications for disclosure by an office holder. And in this particular instance, the district judge rejected my application for an order, and I then appealed that. And that went before Mr. Justice Kitchen. And effectively that appeal was lost as well. Now, the final point of it was that liquidator making an application under Section 236 has to demonstrate a reasonable requirement for the information. And in this particular instance, the application was brought many, many years after the company had gone into liquidation. I was not, in fact, the first liquidator in this particular case. The point of mentioning the case is essentially that it can demonstrate that literally any case can go wrong. And it was one of my first cases making an application under Section 236. And it was a bit of an eye-opener in relation to matters of litigation, because I hadn't expected that case would be lost. And I hadn't expected that the appeal would be lost either. Because if you read Section 236, it basically talks about the ability of the liquidator to apply to court for information from more or less anybody that's got information concerning the affairs, dealings and property of the relevant company. But nevertheless, what it seemed from the way the judgment was structured was that the court wanted the requirement to be effectively proven rather than effectively rely upon the fact that I was seeking to reconstitute knowledge of the company. And one of the things that Mr. Justice Kitchen said in respect of the appeal was that to simply state that a liquidator wants to reconstitute knowledge of the company is really doing nothing more than stating a liquidator's basic function. So the court wanted much more detail in relation to that. So Green vs. BDO highlights the powers of the liquidator, but also the potential limitations and the risk of litigation, because it can go wrong. Questions, queries, concerns, give us a shout. We know insolvency inside out.